Appellate District of Ohio with the Honorable Marilyn Zayas presiding is now in session. Please be seated.
Good morning. Welcome to the First District Court of Appeals. Today is Tuesday, August 30th, and we have 3 cases on the docket this morning. All 3 will be arguing. As I call each case, if you can please identify yourselves and your readiness to proceed. So the first case we have is case number C210615 and 616, which is State of Ohio versus Rassel.
Good morning. Chris Conniser for the city.
Sir Nelson on behalf of the appellate.
Okay. And did I pronounce that correctly?
Russell.
Is it
Delbert Russell.
Russell?
Russell.
Russell. Okay, Russell. Thank you. The next case we have is C210475, City of Cincinnati versus Triton.
Good morning, Your Honor. I'm Bill Geisen, attorney for the appellant Triton Services.
And Nick Pazanka and Joe Neff on behalf of the City of Cincinnati.
Okay, thank you. And I understand, Attorney Pazanka, you're the only one that will be arguing?
Correct.
Okay, thank you. And then we have C210629, 630, 631, 632, State of Ohio versus Thornton.
Laura Peters on behalf of, Laura Peters on behalf of the appellant, Thornton.
Good morning, Ashley Tender on behalf of the city.
All right, thank you both. All right. So we'll start with case State of Ohio versus Russell. Whenever you're ready. Would you like to reserve time?
If I could reserve 8 minutes, please. And morning, may it please the court. We're here for an OVI case that came out of the municipal court that occurred back on July 15th of 2021 involving Mr. Delbert Rasul. On that evening, Officer Sidney Moorhead responded to a crash on a residential street where Mr. Rasul had hit a parked car head-on the opposite side of the road. What Officer Moorhead observed when she arrived was that he'd hit the car so hard that he'd actually ended up across the sidewalk in someone else's front yard. While investigating the car crash after she arrived on the scene, Mr. Rasul was standing roughly 8 feet or so away, talking to the owners of the parked car he had just struck. At this point, Officer Moorhead was not yet speaking to the parties. She was still kind of looking around the crash scene, and she noticed Mr. Rasul fall over, unprovoked.
Didn't she discover later that he had just had a knee replacement?
She did.
And yes. In fact, she didn't do the some of the DUI tests, some of the tests because of his bad knee and bad leg?
That's correct.
Okay.
And that kind of goes to something I was going to approach a little later. One of the things that goes to probable cause is it doesn't require officers to rule out innocent explanations. So at this point, when she's witnessing this, while she does later on find out that there's a reason for it, it can still go into her calculus for probable cause on whether or not to arrest somebody.
However, probable cause will be limited to what the officer in fact didn't know. And it sounds like at the time of arrest, the officer at that point didn't know that there was an issue with regard to the knee.
Correct.
So, although maybe not upon first encounter, but certainly at the time of arrest.
Right, but I would argue that even with a bad knee, an inability to maintain your balance can still be indicative of intoxication. So there may be an innocent explanation, but intoxication could also be an explanation for that.
I understand what you're saying, but and I want you to clarify this for me. Right. My understanding of the record is that the officer, in fact, knew of the knee at some point.
She did find out about the knee, yes.
Prior to the arrest.
I believe it was prior to the arrest because that was one of the reasons she did not perform the walk and turn, one leg stand, those kinds of tests.
Okay. And are you only challenging the determination of probable cause?
Correct. We are arguing that the trial court erred when they ruled that there was not probable cause to arrest based on the totality of the circumstances.
Okay.
And so after she witnessed him fall, she went up and started talking to Mr. Rasul about the crash. While she was talking to Mr. Rasul, she indicated that she noted a moderate odor of alcohol coming from his person. When she asked him about his documents, registration, driver's license. He had the papers in his hands, but he had trouble kind of going through them, is what she testified to.
I've read the transcript, and it seemed to me like there were several different versions of what happened when he was retrieving the documents. It sounded like she said he was in the car, they were in his hands. Doesn't that go to credibility?
Judge, I think she was fairly consistent with that he struggled in some way when he was trying to get the documents out. I do concede there was, whether it was fumbling, whether he was confused, whether he grabbed the white ones or not. There is some issues with consistency there.
Well, yeah, and I think that's the overarching issue here is there was some inconsistencies in the officer's testimony, and there was a lot of lack of recollection in the officer's testimony, and that's what the trial court relied upon from a factual perspective. So, kind of like, how do we get over the factual findings made by the trial court here?
I think the factual findings that we have are sufficient for the lower bar of probable cause.
So you're not challenging the findings of fact?
I believe I believe the appellate court can review the findings of fact, but ultimately what the judge
If
found.
they're challenged.
Yeah, I don't have a whole lot of what's in the record is in the record.
Okay.
I guess what I'm trying to say. But what we have in the record, I believe, does rise to the level of probable cause. Again, that's all we're here for at this point. It's just a much lower bar, lesser than reasonable doubt. And then, as I'm sure the court is aware, the test is just whether the facts and circumstances within the officer's knowledge at the time were sufficient to believe a crime has been committed. And as mentioned here, we have, I believe, the main thing is the crash on the wrong side of the road into a parked vehicle. We have the lack of balance and the falling over, and the difficulty retrieving the documents, the odor of alcohol, and the one thing I haven't mentioned yet is when she was trying to do the one field sobriety test that she did, she indicated Mr. Rasul had trouble following the instructions when she performed the HGN test. And I would think...
Wasn't that entire test stricken because she didn't do it properly?
Substantial compliance, that's correct. But still the interaction she had while observing Mr. Rasul performing the test. We're not talking about the clues here, we're just her interaction with him throughout this period of time. And one of that interaction was, with whether the test comes in or not, she was still talking to him, trying to get him to follow directions, and he was having a hard time doing that. And what we're here arguing today, essentially, is when you take each of those factors, while each one may not rise to the level of probable cause, when you have that combination for Officer Moorhead on the scene that night, that was more than enough probable cause for her to arrest Mr. Rasul for operating a vehicle while intoxicated. And at this point, if there are any more questions, I will turn it over to opposing counsel.
All right, thank you.
Thank you.
And I'll reserve your additional time.
Thank you.
All right.
Good morning, Your Honors. Good morning, opposing counsel, and may it please the court, Sarah Nelson again on behalf of Mr. Delbert Rasul. Under the facts of this case, it's our position that the trial court was correct in finding a lack of probable cause. There was insufficient evidence demonstrating a sufficient indicia of intoxication. No reasonable person would believe that Mr. Rasul was driving under the influence in this case.
I'd like to ask you a question of something that came up. With regard to the HGN, so that was stricken because it didn't because the officer failed to substantially comply. However, the argument today is that the engagement and Mr. Rasul's inability or challenge in following instructions is one of the facts to be considered in determining probable cause. How would you respond to that?
I would say that anything related to the HGN is irrelevant at this point. The state hasn't challenged the trial court's finding with respect to the HGN, so whether or not Mr. Rasul could follow the instructions preceding that test is not a fair consideration for this court. That test has been wholly stricken. And even, for instance...
Even where when it's failure to follow the instructions preceding the test?
I would say that falls within the entirety of the test. We strike the whole test. I don't have case law on that point specifically because no part of the HGN substantial compliance was argued in this case because we're focusing on the probable cause. But with respect to the...
Was this argument made in the briefs?
Not that I'm aware of. No, it was new to me in this, listening to my opponent. But even in that moment, though, I was thinking that there's no way we can consider that. I think it's wholly irrelevant because we strike the HGN, the test itself.
Well, so what about his argument that you have a crash and then you have the odor of alcohol? Like, is that enough?
I don't think so, not under the facts of this case. I think what the case law does demonstrate are three major things. The admission to drinking, bloodshot, glassy eyes, slurred speech, some type of physical impairment, and sometimes there's open containers in the vehicle. When we have one of those three things or a combination of those things, then the moderate odor of alcohol becomes way more persuasive with respect to probable cause. Accidents become way more persuasive with respect to probable cause. But in those two things in isolation of the other big three things that
And she never asked him whether he was drinking, did she?
Correct. She did not.
So this is an issue of law, whether the moderate odor of alcohol combined with the crash, whether that's sufficient for probable cause. Is there a case that you can point us to?
Well, the cases that were cited have more than those two factors. So I'm distinguishing the cases that were cited in the briefs. For instance, I have them. Separate from accidents, we see a lot of officer-observed traffic infractions. So that's what a lot of the cases that are briefed focus on. An officer observes speeding. An officer observes the driver falling asleep at the wheel in the middle of the street. While the cases that are cited don't necessarily pertain to an accident, the officer in this case didn't see the accident, so we don't really know how it was caused, and it's speculative to presume that it was caused as a result of impaired driving.
Were there any witnesses to the crash other than?
I believe there were witnesses on scene, but none of them were called at the motion to suppress hearing, what the officer learned from these witnesses.
And the officer never testified that she had talked to any of them and to try to ascertain how the crash occurred, right?
Correct. I mean, there's no testimony from the officer in this case about her understanding of how the crash occurred. Yeah. All we know is that it was a road that was narrowed by the cars parked on both sides. It was a 2-lane road, but basically only one car could get through at a time. So we have circumstances in this case that could make an accident more likely. It's dark out and you can't really see things crossing the road. If there's a sudden obstruction, you need to overcorrect. We can't rule those things out. And the lack of additional indicia of impairment, in my view, makes the accident less persuasive with respect to probable cause. We don't know how it happened. To address the leg stumbling or the bad leg and causing the stumbling, we do get to rule that out as a factor relating to intoxication, because once an officer has information dispelling something that could relate to criminal activity, it doesn't factor into the probable cause analysis. I think that credibility was a factor for the trial court that this court should consider, because we do defer to the trial court's finding of fact unless there's contrary evidence to what they found, and there was some credibility concerns in this case. The officer did waver a little bit on her recollection. So with respect to him fumbling the paperwork, it doesn't get us over the hump of reasonable suspicion into probable cause. Again, he just got out of an accident. It's not totally uncommon to be nervous around police following an accident. Those are the main points I wanted to address for this court. I think I've addressed some of the questions that you asked my predecessor. If there are any additional concerns the court would like for me to address, nope, then I respectfully ask that you affirm the decision below.
Thank you.
Thanks.
So you have 11 minutes.
Thank you. The main thing I just want to emphasize here, and that in these types of cases, when you're looking at probable cause, it's a totality of the circumstances. The officer can take a number of pieces of evidence, things that they observe, things that they witness at the scene, and put that together in their mind and determine whether or not there's probable cause. And in this case, Your Honors, I just think there is probable cause based on the factors that Officer Moorhead witnessed that night. Again, going through them again, we have the lack of balance.
So let me ask you this. Let's say
Yeah.
that we were to look at the moderate odor of alcohol and the accident. Is there a case that you can point to us that that's sufficient for probable cause?
There is not, right now, again, similar to co-counsel said or opposing counsel said, each case is kind of different with what factors they take in when they're looking at it. I haven't found any case where all the factors are the same. They're all kind of go into this, again, the totality of circumstances analysis that the officers use at the scene. It could be crashes or factors. I mean, the odor is obviously one. As she mentioned, there may be slurred speech or bloodshot glassy eyes, but it's...
I just, like, I don't understand why the officer did not ask these basic questions or why what didn't come out at the suppression hearing. Like, were you drinking? What happened with the crash? Or talk to some of the witnesses and say what happened. Mm-hmm. Like, why didn't, I mean, that's a rhetorical question, I guess. But, like, these are the kind of things that, like, would make your case much stronger. And I don't understand why that wasn't elicited.
Without getting too much into it, some of it was...
You don't have to answer that.
Okay.
It's rhetorical.
There are some answers, but yeah.
Okay.
So again, we're here asking you to find that there was probable cause in this case sufficient to arrest Mr. Rasul for an OVI.
Thank you.
Thank you.
Okay. Thank you both for your arguments. We'll take the matter under submission and issue a timely decision. Have a wonderful afternoon. City of Cincinnati versus Triton Services. Good morning, Attorney Geiser. You can come forward.
May it please the court, Mr. Brzonka, Mr. Neff. Distinguished panel. As I said earlier, I'm Bill Geisen, the attorney for the
Geisen,
appellant
I
Triton
apologize.
Services.
It's my handwriting. It looked like an R to me. Attorney Geisen, would you like to reserve some time?
Yes, I'd like to reserve 3 minutes for rebuttal.
All right.
Thank you.
Whenever you're ready.
As you say, I'm Bill Geisen, the attorney for the appellant. I'm also very honored to have with me this morning Mr. Majid Samargandi, who is the CEO and founder of Triton. Well, panel, we're back here again because Triton did not get a fair trial as a result of some erroneous rulings by the trial judge. Once again, as you know, you handled this case about 3 years ago and rendered a decision in August of 2019. The trial judge erred in failing to follow the mandate that you gave in the first appeal, which I'm going to refer to as Triton number 1.
Before you start on the damages
Okay.
part, I want to zero you in on another issue.
Okay.
And that's the two-issue rule that was raised by your opposing counsel in their brief. I read your reply, but what I'm struggling with is that it was very clear in the jury instructions that the court gave both early notice and failure to follow the resolution procedures as alternate reasons to fine for the city. Correct?
Those were instructions given by the court, yes.
Yes. And looking through the transcript, there were several places where there was testimony that the dispute resolution procedures weren't followed, correct?
Well, they were essentially stalled. Because they were stalled, we never got to the final step, yes.
Okay. So I'm struggling to understand why the two-issue rule wouldn't apply.
Well, the two-issue rule would not apply because the two-issue rule applies when there's a general verdict, and this was not a general verdict.
But the verdict, okay, yes, you're right.
That's one reason, reason.
But let me zero you in even further. So the interrogatories did not differentiate between the early notice provision and the dispute resolution procedures. It didn't differentiate between the two. So could our court expand that part of the two-issue rule to this case? being
No,
that the
because-
interrogatories did not differentiate?
No, because I believe the Wagner case says there has to be a general verdict, and the two issues have to be separate and distinct issues. And the notice provisions and the compliance with the dispute resolution process are not separate and distinct issues. They're woven, they're interrelated. And that's why the two-issue rule, in accordance with the Wagner case, would not apply.
Okay, thank you.
And additionally, on the damages, Judge Bach, I think that what's important to note is this whole damage issue that's contained really within interrogatory number 2. Again, the interrogatory says that was the city contractually obligated to compensate Triton for the differing site conditions which it encountered throughout the project. There are a number of interrelated topics that relate to damages. It's just not the calculation. It relates to notice. It relates to compliance with the dispute resolution procedure. It relates to potential waiver of those provisions. It relates to the party's course of conduct in handling the 5 differing site condition change orders which were submitted. And it relates to the calculation and substantiation of the damage amount. By the judge's ruling, she wouldn't allow our witnesses to testify to those various topics. And as you directed in Triton number 1, it was an abuse of discretion to disallow Mr. Gessner from testifying as to damages. But the court did it yet again. So the damage issue is just not the calculation of numbers. It encompasses a number of interrelated topics.
Counsel, if you were correct, what would be the proper remedy?
The proper remedy would be to, once again, reverse the trial court's errors and to remand this case for yet another trial. That would be it, because I think there was errors in not following your mandate from the first Triton, what I call Triton number 1, by disallowing Mr. Gessner from testifying, and also the trial court in granting the motion in limine, which disallowed us from mentioning any evidence that Mr. Jones, who was the city's project engineer, from directing Triton to submit all of these change order costs at the end of the project, as Triton did with all 5 different site conditions.
Yeah, but on the proffer related to Mr. Jones, specifically with respect to the dispute resolution provision, the question was asked, did he say anything about that? And the answer was no, which is different than Jones told me we didn't have to comply with that. Like that's, so was there any testimony that you were trying to get in through proffer that would have said, Jones said we didn't have to comply with the dispute resolution provision?
I would say yes, Your Honor. And it's not just Mr. Jones, it's Mr. Gessner who was dealing directly with Mr. Jones. Mm-hmm. Mr. Gessner was not able to testify that notice never came up with respect to any of the other change orders. Compliance with the dispute resolution process never came up with any of the other change orders.
But I mean, there's a difference, again, there's a difference between like this didn't come up and the city waived it through its affirmative conduct, through like representations to us. So that's my question. Was there any evidence in the record that the city affirmatively said, you guys don't have to comply with this?
No, because the judge wouldn't let us. That was the whole nature of her motion in limine ruling. We were prohibited from preventing that very relevant evidence to talk about what was the course of conduct between the parties in dealing with the change orders. Mm-hmm. That's the problem here, is that, in the Acura Electric case, this course of conduct and the waiver of the strict compliance with these provisions is what's pertinent here, but the judge wouldn't allow us to present any evidence with respect to that. And so again, it's not just Mr. Jones, it's also Mr. Gessner was prohibited from talking about that. None of those issues ever came up.
So at the end of the day, what you're arguing is that there was essential evidence that was excluded that goes to the determination of waiver. Is that what I'm understanding you to argue?
Absolutely,
summary.
absolutely.
In summary.
Not only with respect to waiver, but I think also with respect to the course of conduct as to how the parties actually handled the change orders on this project. Because for whatever reason, I think because of the erroneous rulings.
And you're saying that goes to an issue outside of waiver?
I'm sorry, please?
The course of conduct.
course of conduct and waiver, I think, are definitely related.
That goes to waiver, doesn't it?
Yeah,
Okay.
they're related. But I think that what you'll see is that the court, through the erroneous rulings, treated this, what I'll refer to as change order 14, which was the comprehensive change order request, treated it as an outlier without justification. Because if you look at the other 4 change orders that were submitted, and I urge you to look at page 13 of our appellant's brief that shows the 4 that were approved, that, if you look at that chart, what it shows that,
What do you mean treated it as an outlier?
well, that's what I just want to explain.
Okay.
All 5 change orders were submitted at the end, after the project had finished, all 5 of them. Additionally, all 5 of them identified the additional labor, material, and equipment that Triton had incurred in encountering those differing site conditions. All 5 of them showed that Triton had submitted them anywhere from 7 months to a year after they had actually encountered the condition. Each of them were personally calculated by Mr. Brian Gessner, who was Triton's site director, as well as the project manager, based upon his firsthand knowledge of the project. 4 of them were approved, although anywhere from 10 months to 2 years down the road. But the reason, for whatever reason, through these erroneous rulings, the court treated it as an outlier because suddenly, with change order number 14, based upon their objections, they're saying that Mr. Gessner did not have firsthand knowledge, did not have experience to calculate the numbers. They suddenly said that he needed to be an expert in order to calculate the labor, material, and equipment associated with that change order.
Mr. Geisen, wasn't part of the issue, though, the fact that it wasn't just the calculation, it wasn't just, it was the fact that all of the others were very specific about where the differing site condition was and what it consisted of, while 14 said differing site conditions throughout the project, and it wasn't specific. Isn't that part of the issue?
That's part of what the city is arguing, yes. But what's important, Judge Bach, is the jury ruled unanimously that Triton did encounter differing site conditions throughout the course of the project.
Right.
And that was a finding that the city vehemently opposed. So the jury recognized that there were differing site conditions throughout the project, but the judge would not allow Mr. Gessner to testify as to the specific labor, material, and equipment that Triton had expended relating to those differing site conditions.
But here's what I don't understand about your argument in response to Judge Bach's question. As I'm reading your brief, rereading your brief right now, when I look at the first assignment of error, that seems to be solely limited to damages. And when I look at the third assignment of error, which is related to Mr. Jones, I don't see any discussion of Mr. Gessner's testimony. So what testimony are you saying that he did not get in that was excluded that relates to something other than damages?
Other than damages?
Yes.
Judge Bergeron, I'll tell you exactly what we weren't able to get in and to tell the jury. We weren't able to tell the jury that Mr. Jones was aware of differing site conditions throughout the course of the project because he told his own colleagues that in an email. We weren't able to tell the jury that he had directed Mr. Gessner to submit all of the differing site conditions at the end of the project because his primary concern was getting the pipe in the ground because of this project that he had labeled as the most difficult project that he had ever encountered in his career. So he was focused on just get the pipe in the ground, we'll deal with potential costs later.
That email, was that email admitted?
Was it admitted? No, I don't believe it was admitted. Because it was excluded because of the motion limiting order.
Was it proffered?
Yes, it was proffered, yes. We weren't also able to tell the jury that Triton relied upon the direction of Mr. Jones to submit all the costs at the end. We also weren't able to tell the jury that Triton had submitted a total of five change orders relating to differing site conditions at the direction of Mr. Gessner. We weren't able to tell the jury that the 4 differing site condition change orders that ultimately were approved did not compensate Triton for the comprehensive differing site conditions, whereas the city was allowed to tell the jury that, oh yeah, Triton was fully compensated for all the differing site conditions which it encountered on the project. Mr. Gessner was not able to tell that to the jury. So we were robbed of many opportunities, Judge Bergeron, to tell the jury exactly how the parties handled these differing site conditions, and as a result, it severely prejudiced the jury's view of all of the evidence, and I think what ultimately led to their answering interrogatory number 2 as they did. And I think that what this all gets to is something that you aptly, it wasn't the three of you, but this court wrote 3 years ago. You said that any deficiencies in Mr. Gessner's testimony goes to its weight, not as to its admissibility.
That was based on a different evidentiary rule, correct?
The city did argue, I think, Rule 401 or 4, I forget which number. Yes, 401, 402, or 403 in that case. Now they were arguing Rule 702. So it was based upon a different rule. But I will say, Judge Bach, that the Court of Appeals, you all had the authority, if you had wanted to, 3 years ago to say, and despite the errors that were made, we believe that Mr. Triton needed expert testimony.
That wasn't before the court.
I know it wasn't before the court, but I think you have the authority to affirm the trial court on other grounds. And I think it's important that this court never made that determination. Besides, Ohio law is far from clear that an expert is needed to calculate these types of damages. The Fiorelli case, which we cited in our brief, says that an expert is not necessary to calculate these kind of damages. And again, this gets back to what Judge Zais was asking me is about why this was an outlier. For the 4 other change order requests, Mr. Gessner calculated them based upon his personal review of the evidence, et cetera, et cetera.
And there was no objection to that at all from the
No
city for
objection.
any of the other change
They
orders?
ultimately approved them.
Okay.
But for this one, suddenly, you need an expert, which is crazy. That's not how the construction industry works.
So is there a different standard, though, for calculation of damages when there's no when there's no active court? Basically, is it different in court and out of court?
I would say absolutely not, because these are change order requests that are submitted during the course of the project. And again, what Mr. Gessner was calculating, no differently than what he did with the other 4 change orders, which were ultimately approved, is he isolated the labor, material, and equipment that additional labor, material, and equipment that Triton had incurred in calculating the comprehensive differing site condition claim. And what the jury was not allowed to hear, this is another thing, that he had subtracted out all of the other change orders that Triton had submitted for differing site conditions. Because when Triton submitted change order number 14 in March of 2013, the city had not approved the other 4. But he went through a very methodical process to identify the labor, material, and equipment for the comprehensive one and subtracted out the other ones. The jury wasn't allowed to hear that.
Attorney Geisen, so you're out of time, but I will reserve your 3 minutes.
Okay. Thank you.
Thank you. Good morning.
Good morning. May it please the court, Mr. Geisen. Nick Pazonk on behalf of the city of Cincinnati. So let's not forget how this case actually started. The city initiated this action when Triton refused to reimburse or to give back.
I know, we're very familiar with that.
$500,000. Yes.
Yeah. I'm sorry, I'm going to interrupt your train of thought. So my concern related to what Mr. Geisen was just arguing is the 403 analysis for Mr. Jones's testimony, because if you're assuming 403 applies, that's an acknowledgement that the evidence is relevant, and then you're having to say it substantially outweighed the prejudicial value substantially outweighs probative value. And I just don't understand how this is so prejudicial to you all that you suddenly get a 403, get out of it under 403.
we tried to get out of it on 403, and this court said that no, it was under 403, should have been admitted. But what this court also did was said, we're making no determination on any other rule. On
No, no,
Section
I'm
2.
sorry, I'm talking about Jones, not the damage question.
Okay.
Yeah.
So on Mr. Jones of not being able to say, submit the change orders at the end of the project.
Correct.
So that's essentially saying that you're waiving, you don't have to comply with the contract. And the Ohio Supreme Court in the Foster Wheeler case said that engineers like Mr. Jones cannot waive contractual provisions. So it's based on that.
Are you suggesting that there's a rule of law that under no circumstances can people like Mr. Jones waive contractual provisions?
If they have the express authority. And if you look at the contract, it's section 105.01 of the city supplement sets forth that express authority. And under that, there's like 5 or 6 things that an engineer has the express authority to do, and not listed in that is any ability to waive contractual provisions. And so the other point I want to make is what Judge Bergeron, your question was, well, is there any evidence that Mr. Jones said you do not have to comply with these contractual provisions? It's just submit these change orders at the end of the project. There isn't. There is nothing.
Wait a minute. So I'm looking at the transcript right now, and in the proffer, it says, my question is, did MSD advise you when you should submit your costs for the various differing site conditions? Answer, and this is from Mr. Gessner. Yes. On the date site condition claim, I was directed to figure it at the end by calculating the overages, which allow me to put costs on those. And then it was asked, well, who told you this? And the answer was Mr. Jones.
Yes.
So to me, that is saying that I was told to do this at the end.
Oh, without question.
Okay.
So we're not disputing that. It's do not comply with the early notice provisions. Do not comply with the dispute resolution provisions. That's not in the record. What's in the record is submit all this at the end of the project. So it's those contractual provisions that are important of early notice, of dispute resolution. What Mr. Jones or Mr. Gessner never testified was Mr. Jones told me I did not have to do that. That's not in the record, and that's the distinction that we want to make.
I'm not sure that he's arguing that there was like a direct evidence of waiver. That
he's arguing course of conduct too. What they
Right.
also argued was the direct evidence as well. And the course of conduct, if you go back and look at the record,
well, I shouldn't say direct, an express waiver.
what they're saying that the trial court prohibited them from introducing as evidence is Mr. Jones saying, submit these at the end of the project.
Right.
So, well, our position is, so what? That doesn't change anything, because what isn't in evidence is do not comply with these contractual provisions, or do not.
And let me make sure I understand, like, so if they're submitted at the end, and then there was a dispute about the validity of the change order, is your position, well, the dispute resolution provisions in the contract can then be pursued at that point, because then there's a dispute and you can follow that?
Correct.
Am I understanding that right?
Absolutely. So it's we don't know what the claim's going to be until we get it, of course.
Right.
So that's why there's still notice is important of, hey, we've got these issues, and they're throughout the project. That's not in there, and that's what the jury found. So it never even got to the issue of damages, and I think this goes to Judge Bach, your point on the 2-issue rule that is the critical issue here. The jury found that the city was not obligated to compensate Triton for the differing site conditions that it experienced. And if you look at our interrogatories that we propose, and I think it's in the journal entry of 274, we wanted the jury to answer each question. Was there early notice? Did you comply with the dispute resolution? And what the court did and what they were fine with was condensing all those down into 3 general interrogatories. 1, were there differing site conditions? 2, if so, was the city contractually obligated to compensate Triton? And 3, if so, how much? And those are very general, and there can be multiple reasons for the jury's finding on that second point.
Well, can you address Mr. Geison's argument that the early notice provision and the dispute resolution provision, they're intertwined? Because, step one is provide early notice, correct?
Correct.
And then there's step two, and then there's step three. So you can't really get to step two by the contract. You can't get to step two or step three until you do step one, correct?
That's why there's multiple steps, yes.
Yes, so my point is, aren't they related then?
In that sense, that it's a step-by-step process, yes, but the jury can find that they did not satisfy any one of those steps.
But they wouldn't have satisfied, by definition in the contract, they wouldn't have satisfied the dispute resolution procedures because they didn't give early notice.
Which we're left to guess of what the jury found.
No, I'm asking you, could the jury have found that they followed the dispute resolution processes without finding early notice?
No, because notice has to be first provided, then you
Okay.
go through a dispute resolution, then if you get, then you have to submit a certified claim, which there's no evidence of a certified claim, and then only after you submit the certified claim do you file a lawsuit in court. And so any step of that process, the jury it could have found that they didn't provide notice or they didn't engage in dispute resolution, and we're just left to wonder. And they did not appeal the dispute resolution provision or anything related to the dispute resolution.
So what about his point that this is not a general verdict form because there are questions? I hear what you're saying, which is that, well, with this question in particular, it subsumes at least two issues. But what is your response to that?
Distinction without a difference. Because we're still left to wonder. And I think that's what the law is, even though it speaks of general verdict forms in the absence of interrogatories. At the end of the day, we're left to wonder which thing the jury found when answering that question.
So in other words, like if it was a negligence claim and it didn't break out, duty, breach of duty, causation, damages, we don't know which element the jury might not have found, so we...
Absolutely, yeah. So, if I can just jump around because I don't know where your honors want me to go, but on the notice instruction, there's some issue that they take with the notice instruction and saying that it improperly shifts the burden to Triton to show that they provided notice. As this court is aware, you read the instructions in the context of the whole charge, and when that's done here, I think it's abundantly clear that the trial court properly instructed the jury. So the burden of proof section states, and this is Journal Entry 290 at page 7, the party who claims certain facts exist must prove them by a preponderance of the evidence. And then the written notification instruction says, and it says expressly, the city is the one that's claiming this. So I think when those two charges are read together, or those two instructions are read together, the entire charge is appropriate. So I don't know if your honors have any additional questions, but I think I'm finished, and I think we'll just ask that the court affirm the trial court.
Actually, before you're finished, I want to ask you one more thing about the damages. So Mr. Gessner, is that
Correct.
his name? Mr. Gessner calculated the damages for all of the other change order requests, correct?
Correct.
The city didn't object to that.
Correct.
And those were actually accepted after 14 was submitted, correct?
I say they accepted it. There was plenty of negotiation, which ultimately resulted into an acceptance. Correct.
So my question is, why was it okay for him to calculate the damages on those, but not on change order 14?
Well, 14 was different. Like I think Your Honor recognized that was an all-encompassing, and it was a much higher dollar amount. But I think the other point that you made was they weren't in the court at the time. The rules of evidence apply. And it's not our position that an expert is required in every single one of these cases. I think the law is clear that an expert may not be required, but it is a rare case in which it's not required. And the judge, Judge Cross, hearing the facts and the evidence in front of her, said that based in this case, yes, an expert's required because that's where you're going is to expert land, and I'm not going to let you do that. But to your point, 14 was different. We weren't in court, and we didn't have an opportunity. Perhaps maybe the city should ask for those change order monies back, but we're not going to do that. So that would be my response to that. Thank you, Judge.
Thank you.
Judge Brock, I just want to address a question that you just asked of Mr. Brzonka. He says there was a negotiation of these other change orders. It's important for the 4 change orders that they improved, and I'm using very round figures. Triton had submitted a request for roughly $207,000. The city approved all but I think about $13,000 of that. So it proves that Mr. Gessner knew what he was doing, and the city accepted his background and experience when they approved those change orders. I think that's important. I was really shocked to hear Mr. Brzonka say, we are not disputing the fact that Mr. Jones directed Triton to submit the costs at the end of the project. I'm shocked because that was the whole nature of their motion in limine, that they wanted to keep all of that evidence away from the jury. So if they don't dispute the fact, then why did they work so hard, and they were successful in front of the judge, to keep that from the jury? He says, so what? It handcuffed Triton into presenting its entire case and allowing the jury to fully answer interrogatory number 2, namely, was the city contractually obligated to compensate Triton for all those costs? Mr. Gessner would have testified, had he been allowed to, that notice and compliance with the dispute resolution process never came up with the 4 that were approved, and most importantly, with change order number 14. That was never, ever an issue. And, you know, the record shows that he had over 50 communications with the city just with respect to change order 14.
Help me out here, because if I don't understand why the dispute resolution provision would come up unless there was actually a dispute. And if there is a dispute and Jones says, don't worry about the dispute resolution provision, we're not going to hold you to that. Like, that's one thing. But like, how is his testimony relevant on the facts here?
Well, I think, Judge Bergeron, when Mr. Gessner was meeting with Mr. Jones, who is the designated person under the dispute resolution process, they are trying to resolve the dispute. So that is part and parcel of the dispute resolution process. But be that as it may. And I think that it's also important that Mr. Jones, had we allowed to get this in front of the jury, he was aware, there's written evidence in his own email that he was aware that Triton was complaining about bad ground throughout the course of the entire project. There's also written evidence that he had said that Triton did a remarkable job in communicating on this project. The jury wasn't allowed to hear all of that evidence. I think part of the problem is, and I didn't talk about this at the beginning, in my first time before you, is that the judge did give a waiver in course of conduct instruction. But Triton was handcuffed and wasn't able to present any evidence to support that instruction, primarily in light of the motion in limine order. So, yeah, we got an instruction. We weren't allowed to submit evidence. The city was, but we weren't. So that's what really hampered Triton's presentation of the case. Additionally, I think that, particularly in light of the mandate that you had in the first appeal, that Mr. Gessner should have been allowed to testify. That's what you directed. That's what Judge Cooper, who was the prior judge, had decided in her denying the summary judgment motion that Mr. Gessner could testify as a fact witness. And I think that if he did present any opinions, they were certainly qualified lay opinions under Rule 701 because they were based upon his personal perceptions and would have been helpful in explaining his damage calculation to the jury.
You have about 30 seconds.
Well, let me wrap up then. So in conclusion, what this case shows is that when the jury hears all of the relevant evidence, as it did with the differing site condition claim, it ruled unanimously in favor of Triton, despite their vehement objection to that finding. However, in light of the errors which the judge made, when the court and the jury, I'm sorry, in light of the court's errors, the jury only heard one side of the evidence with respect to notice, compliance with the dispute resolution process, waiver, course of conduct, and damages. The court not allowing Mr. Gessner to address all of those topics is an abuse of discretion, similarly as that you had ruled in Triton number 1. The court's error obviously led to the way that the jury answered interrogatory number 2, so I ask that you please allow Triton to finally present all of the relevant evidence to the jury so that the parties have an even playing field in front of the jury. So I respectfully request that you reverse the errors that the trial judge made and remand this back for yet another trial.
Thank you.
Thank you.
Thank you both for your arguments. We'll take the matter under submission and issue a timely decision. Have a wonderful week. Good morning. Good morning, Attorney Peters. How are you?
I'm fine, thank you.
Would you like to reserve time?
3 minutes, please.
3 minutes, all right.
May it please the court. My name is Laura Peters, and I'm here on behalf of the appellant, Quinetta Thornton. In State versus Adrahano, sorry if I butchered that, 153 Ohio App 266, 2003 Ohio 3822. This court cautioned that courts should be slow to intervene between parents and children. We ask this court to exercise that same caution and reverse Ms. Thornton's convictions for domestic violence. As this court is probably well aware, it is a long-standing held liberty interest that parents have the fundamental liberty interest in the care and custody of their children. But as part of that care...
Right. But, I mean, the facts here seem pretty egregious in terms of the testimony about what prompted the investigation by the neighbor and then what the officer witnessed upon getting to the premises.
Well, yes, the neighborhood, some screaming, but he acknowledges that, when at first he went out there, what he thought what it was being was minor discipline. And it's only after he was hearing it go on, but, there were 4 children that she was disciplining, so that after like the 10-minute mark, he decided he was going to call the police. And yes, the officer came up and he testified that he could see through the blinds, and there was only that he perhaps saw 1 strike. We actually don't have any testimony or any evidence as to actually how many times any of the children were struck.
But there kind of was, because there were multiple welts on all of the children.
There classification, yes, that there were some welts, but there was some on like a left leg, but it was a belt, so it doesn't necessarily mean like the boy Marquise, had it on his left leg.
Please don't use their names.
Oh, I'm sorry, I forgot. The boy had, on his left leg and then also on his arm, but there's testimony that he's turning and stuff, so that could explain the belt potentially hitting more than one spot, and also, there is no per se prohibition against using a belt as part of corporal punishment.
But wouldn't it seem that if the point was discipline, that once she noticed that her children were all squirming and moving as she was using the belt on them, that she would have stopped because she was hitting them on places other than their bottoms? If she was, connecting on their arms and on their legs and other places, shouldn't that have occurred to her to stop at that point?
Well, there is evidence in the record that she was trying to tell the children to turn around and not to move. So she was trying to take, in order to, yes, she was trying to carry out her discipline, but she was also trying to caution the children. She was expressly stating, you can hear it on the video, that she didn't want to hurt them, that they were causing potentially more injury to themselves in different places than what she intended. So it is about what her intention is, and with the parental discipline. And there was a case where, oh shoot, no, shoot, I didn't write down. I think it's listed in State versus Smith, which is 2019 Ohio 2467, where a child was squirming, and there was multiple, on his hands, and ultimately his, the conviction was reversed, I believe, in that case. So yes, the children are squirming, but she also testified that there was that they were just making a lot of noise, and that they were actually screaming and yelling when they weren't even being hit. That, her testimony is, and there's nothing to dispute it, was that the belt was making contact with her as well as the bed. And part of the parental discipline is whether or not this was reasonable, and what you consider is whether or not the harm was excessive to the child. And here we have no evidence that the harm actually was excessive. Yes, we had evidence that night, that there was some red marks, maybe some welts, but there was no evidence that how long these welts lasted. So other districts have said that if bruising lasts for days or a week, that's a sign that the force used or the discipline was excessive. We don't have such testimony in this case. We only have what they said that happened that night. And also, she, sorry. What happened that night, so we can't declare, there is no evidence to say that what she used was excessive. And then, and again, was it proper or reasonable? So the factors are, you consider she did try to use non-corporal punishment. From initially, she said how she yelled at the children, and then she took away their TV, their tablets, their phones. So she tried other parental techniques of discipline to try to get the children to comply with her order to clean up the house. And instead of complying, the children were creating more of a mess, and actually the two youngest ones were fighting, and apparently there was water then that was spilled in the living room, and the couch was wet. So yes, so the discipline needed to be she escalated, and so she decided at this time that she would do the whooping that she had been raised on. But there's nothing in the record that says that what she did again was excessive, or that it wasn't proper to do to use a belt. So unless the court has any further questions, and I know there was an assignment of error about the amount of continuances. If there's no questions on that, then
No.
Thank you.
Thank you. Good morning, Attorney Tucker. How are you?
I'm great, how are you?
Thank you.
And good morning, Your Honors, and as well as opposing counsel. My name is Ashton Tucker again, and I represent the city of Cincinnati in this matter. I'll address the specific arguments that counsel has brought up this morning, which is specific to discipline as it relates to whether we have met the threshold between parental discipline and abuse. I'll note that there are no prohibitions against corporal punishment specifically. The prohibition is against abuse. We have testimony that what happened that night did extend beyond what would be reasonable. I'll note that State v. Cook, which is 2021 Ohio 3841, states that the court has to consider and the defense has to propose that the discipline was proper and reasonable based on the totality of circumstances, considering the age of the child's behavior before the punishment, the child's prior response to non-corporal punishment, the location and severity of the punishment, and the accused's state of mind. I'll note that there was testimony that she had attempted non-corporal punishment prior that night. However, I think the crux of the state's case is that it went beyond what is normally considered reasonable. We had testimony from, I believe, 5 states' witnesses that testified to what was largely consistent evidence. We had the neighbor who testified to hearing the sounds and waited before he called the police because he is of the opinion and perhaps had been the subject of said punishment as a child and waited. And when he continued to hear it for a number of minutes, he then called the police. We then have testimony from Officer Pappas, who from 100 feet away also heard the same commotion. And that's an amount of time past the phone call to 911. He also looked in the window and saw children cowering, as well as the belt coming down to strike the children. Yes.
Ms. Tucker, are you proposing, or are you suggesting that the use of a belt would always or almost always justify a conviction for domestic violence?
No, I'm not. I recognize that the use of a belt is actually, I would say, a fairly typical instrument for these things, but we're not talking about one strike. We're not talking about one strike to each child even. We're talking about a number of strikes over a number of minutes over to the point where the neighbors are hearing things, to the point where the officers are witnessing these things as they happen. I'm not saying that there should be or that there is case law that would prohibit the use of a belt specifically, but I am saying that it prohibits the use of a belt in this way for this amount of time and with this severity. And again, well, we have testimony from Ms. Thornton herself, as well as from officers, that she admitted to hitting the children, that she admitted to wanting to hit the children. And we have testimony from an EMT as well as a JFS worker who noted welt marks on each child that were fresh and significant. The JFS worker in particular noted that these were consistent with belt marks that she had seen in her own work as a JFS worker. All of these witnesses were credible and notably consistent with one another, and what they testified to was the extent and severity of this particular beating. While I don't believe that, I'm not asking for this court to find all of these types of situations to be prohibitive, but I am saying in this case that it is prohibitive. Again, the city testimony from the city's witnesses were extensive and consistent and credible. I think that what we have here is not a case of parental discipline, but we do have a case of abuse considering all the factors.
Ms. Tucker, can you refresh my memory?
Yes.
There was a separation of witnesses during trial, correct?
I believe there was.
Okay,
Yes.
thank you.
I believe there was. And again, the only person who may have been in the courtroom the entire time was one of the officers who would have been designated as a state's witness. But other than that, there should have been a separation of witnesses.
Thank you.
And again, I think that the testimony here, the record speaks for itself. What we have is a case of abuse and not a case of parental discipline. And if there are no further questions from your honors, I would ask that this case, or that this court affirm the trial court's findings, and I'd submit on the brief. Thank you so much.
Thank you.
Just quickly, Judge Bach, yes, there was a separation of witnesses ordered, for sure.
Thank you.
Yeah. And Ms. Tucker, talks about how that there were 5 state witnesses in this testimony, but most of them were testifying to after the events, not actually to what was occurring. So none of the witnesses could testify as to how many times any of the children were struck. Now, my client also testified that there were times where she struck the bed purposely in warning, so that would make a noise and they would hear screaming and yelling. But that doesn't necessarily mean that she was actually striking any child at that time. She said she was to get their attention. Yes, she acknowledged that she did hit them, but this was for discipline. It was not to beat them, not to abuse them, but because they weren't.
So are you asking us not to consider the welts? I'm not sure what your argument is with regard to that.
What I'm arguing, yes, I don't deny that there was testimony that there were red marks and that they would characterize them as welts. I do not deny that. But when you're doing corporal punishment, there's going to be some harm. And the courts have recognized that. In the Adrahano case, where this court decided, they mentioned that. You can't just, there's going to be physical harm, but is whether the injury is an injury that's recognizable by law, and a child doesn't have a right to avoid parental discipline. So whether or not there is going to be some harm recognized there might be a mark. The question is whether or not that those marks, that bruising was excessive. And that there was no testimony in this case that these marks lasted beyond that night. There was no, they didn't have the caseworker who, JFSA, the intake worker didn't say, oh yeah, we still noticed them the next day, or when we placed them with the aunt, or we did case study. There was, he just talked about, yes, there was a safety plan put in place, but no one testified to how long any of those marks might have lasted. And there was some question about whether on the 5-year-old, whether or not the mark that they were describing was actually a welt that was arised from being struck by a belt, or it was like a bug bite, and she also had some prior injury from play or just being a child. And further, the EMT who testified also said that the children didn't require any medical attention. So there was no testimony that they had to ice the injuries or put any balm, or there was nothing about how any of the children were treated after the fact. So again, there has to be proof that this was excessive. And we're going to submit that, in this case, that the state failed to show that there was excessive injury, and therefore Ms. Thornton should not have been convicted because she was just properly exercising parental discipline. If no further questions, we'd submit on the brief. Thank you.
Thank you. Thank you both for your arguments this morning. We'll take the matter under submission and issue a timely decision. Have a wonderful afternoon.